Hello, everybody. Someone's already waiting. How are you guys doing tonight? I'm so happy you're here. Hello, Nana Laura. Hello, Buzzy Pug. Hello, my forever puppy. Hello, Wire Mother. Hello, Otto. Hello, Jerry Matthew Boyd. Did I say hi to you yet, sis? I think so. I think I did, because that's when Ava jumped up. But I'm going to do it again. Hello, Buzzy Pug. I don't want to accidentally forget you. Hello, Mortimer Duke. Hello, Jenny Green. Hello, Eileen and Carlin. Hello, Donald Westerdale. Oh, hi, matey. Everybody's favorite. Yeah, she's a good girl. She's a good girl, aren't you, Ava? Everybody's favorite girl. Come on. There you go. There you go, baby girl. One of the kitties is using a scratching post. Tiny Kitten found a stack of my mail that I was, I set to the side for shredding. And she figured she'd help me out. Yeah. She pawed about that much of the stack onto the floor. And now she's using it as a pillow. Tiny menace. Oh, I know. And they're spoiled. They are spoiled rotten. 100%. And then some. She has been doing that in the basement. I have been finding newspaper that I had wrapped dishes in and boxed, and my cleaning person that I used to have took all the boxes downstairs for me. Well, I had to go down and do laundry one day, and I realized that there was shreds. The boxes had been entered, and the paper was everywhere. There's only one of them that would do that. Oh, yeah. He is keeping his eye out for Tiny Kitten's mom. Yeah, he doesn't like her. He does not like her, not one bit. But she comes and gets warmth in the Coleman Palace, and sometimes there's kitty kibble in there, and he's not happy about it. No, he's not happy happy about it. He thinks he should be the only kitty. He's the king. So, hello, Spider-Man, honey. Hey, quit that. Watch that tail. I got stuff I don't want you hitting with your tail. You're gonna knock stuff all over. That should be a hint. We've got a couple of Ricky FTCs, and we're gonna start out with just a funny Mogan clip. I love her. She's great. She's really great. And she had a defendant. Oh no! Tiny Kitten Esquire Postal Delivery Service. Yes, yes. Judge Mogan is. And so is Ava. But yeah, she had a gal in there today that innocently made a gesture, and Judge Mogan was not quite sure what she saw out of her peripheral vision. It's delightful. I made sure to cut it and paste it a couple of times so y'all could get a good view.
So whenever you're done, let me know. I do have to go on the record for at least Darren, well, for all of them, because I think they all had to post.
Let it never be understated the danger of peppermint mint schnapps.
I can believe that.
Jason Farrell, my client here at 2. I'm just wondering.
So when the judge comes out, everything's ready, okay? All right. They'll call you and go from there. Thank you. Just be respectful. If it's other one's turn, okay? All right.
I see someone. I see you. Hello. Can you see me?
No, I can't see you.
I can see you. Hey, wait, I can see her. Oh, shh. We gotta be quiet. I didn't know. I didn't know. Okay, my bad, my bad.
Jillian.
I didn't say nothing. He said something.
I said something.
I know, but don't be respectful because the judge is about to get on here, okay?
Okay.
She isn't.
Okay.
Shh.
See, now we gotta be babysitting.
No, because there's other court going on. We gotta be respectful.
That's Miss Campbell right there. And I don't know, what was Miss Campbell just doing?
Oh, I like the gavel, you know, like when you like,
Oh,
because you said
okay.
face to face.
All
I'm
right,
sorry.
just wanted
All
to
right.
make sure that we're all good. It's all
Oh yeah,
on the up
my
and up.
bad. My bad. I watched too much Law and Order, Your Honor. I'm sorry. All right.
That's okay. I just caught it out of the corner of my eye. That's all.
Okay.
We will go on the record in the matter 26 CF 14, State of Wisconsin versus Lillian Campbell. The state appears through District Attorney Kevin Schmidt in person. Ms. Campbell appears by video conferencing in custody in Burnett County Jail. We have her counsel, Joel Feliski, appearing in person. We're set today in this matter for an initial appearance. Mr. Feliski, were you able to go over the criminal complaint with Ms. Campbell?
I was, Your Honor. I believe she understands the charges here and the maximum penalties. We'll waive formal reading, enter in a not guilty plea to the misdemeanor. We'll also waive time limits for scheduling the preliminary hearing.
All right, not guilty plea will be entered for the misdemeanor. And we can get the prelim in and/or a waiver. I know that at least at the last hearing, Ms. Campbell, we had a bond modification hearing. And she indicates that there is a warrant out of Duluth, out of Douglas County. But I'm not sure if this is something she wants to try and take care of in a quicker fashion to go resolve the things in Duluth,
Yes.
or not in Duluth, I'm sorry, in Douglas County, not.
Yes,
So then I could set this is Jose's, correct, Mr. Schmidt?
Yes.
We can do something next week. If you want to get it, do you want it more on a fast track, Ms. Campbell, to try and see if we can get it resolved, or do you need
Yeah,
to talk to
fast
Mr.
track.
Feliski?
fast track. Fast track.
I could do, okay, I can do March 4th at 10:15, if that works.
That will work.
All right, March 4th at 10:15. Bless you. So I'm not sure if you received a prelim offer, probably not. Since
I have not, but I'll be discussing that with the state.
Sounds good. Okay, we'll see you then. If by chance, I don't know, but you're probably going to need to look at discovery and do all of those things. But if she does want to get it resolved and there's an acceptable resolution that you and she find, we can take care of it. We probably could take care of it next week or very soon thereafter. Okay.
Thank you, Your Honor.
All right. Thank you. We are adjourned. Ms. Sherwood? We will go on the record in the matter 26 CM 30, State of Wisconsin versus Jason Friel. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Friel by.
I am very jealous of his hair. I'm not gonna lie. He has beautiful hair. I don't know how he does it, because jail life's hard on hair.
Video conferencing in custody in Burnett County Jail. We have his counsel, Amber Sherwood, in person. We're set for an initial appearance, but off the record, I believe I was informed that this matter may have resolved. Is that correct, Ms. Sherwood?
Yes, it's my understanding that this matter will resolve in a forfeiture.
All right. And didn't I hear something about restitution?
Correct, forfeiture with a restitution request, which I believe I've gone over with Mr. Friel adequately and he wishes to accept.
All right. And is this something that's prepaid restitution, or is this something that you're indicating, Mr. Schmidt, that it can be paid in payments?
Given the amount of it, I'd need some of it prepaid up front. It's $950.
All right. So what is the offer? How much prepaid?
It's a half,
So,
$475.
so I'm not sure what you want to do.
We were not made aware that we would have to pay anything up front. Mr. Friel has been in jail for 25 days. Any employment he had, he no longer has. And all of his stuff, including his wallet, were at a house that he has a TRO against and cannot get to, even if he had the money to prepay that, Your Honor.
And bail is only at $500. So
That sounds like a big ol' him problem, huh?
Does he have any amount he can pay?
Not currently. He needs to be able to get to the sober living home, which he is going to be at Ruth's house.
Mr., is it Friel or free? How do you say it?
Friel, Friel.
Okay, I thought so. Mr. Friel, would you have the ability to get a job and to get a job soon?
Yes, I mean, I'm going to the Ruth house. Pastor Jack's coming to pick me up, so I talked with my lawyer.
Okay.
I used to have a roommate that had hair about twice as long as that. His hair literally went down to the crack of his behind. It was gorgeous. It was real wavy. And he did have facial hair. You know, he had a beard and a mustache, but during 2020, he would walk around town wearing his COVID mask. And when he would get catcalled, he would make it a point, you know, he'd have people, guys hanging out the car window, you know, saying, "Oh man, you're so fun." He'd turn around and be like, "Thank you." It was hilarious because he had a very deep manly voice. He made sure that they knew it. I've never seen so many red faces after a cat call. It was great. Oh, good times in 2020.
I am not opposed, unless the state's going to argue against it, to amend bond. He's been in custody for 25 days, as long as he understands that there is an absolute no contact of any way, shape, or form, even through third parties, unless it's law enforcement or counsel.
Yes, Your Honor.
I need to verify that I have the bond conditions set. Absolute sobriety, no alcohol, no illegal substances or drugs, no bars, taverns, liquor stores, those types of things, random testing, blood, breath, or urine, no contact with Donna Friel or the residents. Do you understand those conditions, Mr. Friel?
Yes, but there's one thing I'd like to bring up that I have talked to my lawyer about, if that is all
About your
right.
medication?
Yes,
That is something that would need to go through law enforcement. Ms. Friel filed a temporary restraining order that is in effect, that was granted. There's a hearing on March 5th. That is something that would need to be addressed on March 5th through the injunction, the restraining order portion. However, you may, I guess, I can put on, since I'm amending bond, I can put on one trip with law enforcement to go get medications and
personal stuff.
some personal belongings, but you understand, Mr. Friel, it's just gonna be quick, grab some clothes, grab your toothbrush, grab your deodorant, those kinds of things, you understand? And so it'll be a quick in and out.
The other question I had was that, because you asked me, you're saying I got drug tests and everything, my medication shows up as an amphetamine, so if I continue taking it, is that gonna affect anything? Because I need my medication, I need to be on it. I've been on it for 4.5 years and it helps me.
Doctor, I would need to see the prescription and either the prescription from the doctor, something of that nature, to verify that that is the medication. And then it's easy to verify if that test as an amphetamine.
Oh, yeah, yeah, I have all that
Okay.
information. Thank you.
All right, converted to from a cash bond to a signature bond. I am going to tell you and warn you, Mr. Friel, that if you violate any of my bond conditions, if you are told that you must leave the Ruth house, anything like that, the court will convert this back to cash, okay?
Yes.
So let's get another date and time. Hopefully he's going to be able to come up with the 475, half of the restitution. This is a Jose's case. April 15 at 10.
Does that work for you, Mr. Friel?
It's going to have to.
Perfect.
So he's at the Ruth house. I do have Pastor Jack is here. Glad you look like you're doing well. Good to see you back. If he's at the Ruth house, he may appear by video conferencing. He doesn't have to drive all the way down here. However, if he's able to raise that money and get that paid, the matter can be resolved. It can still be resolved by Zoom, as long as half that restitution is prepaid. Again, if he is no longer welcome at the Ruth house, it will be converted back to cash and he would need to come back to custody. So, what? Thank you. So mind your P's and Q's, okay, Mr. Friel? Do what you need to do. Stay good, follow the rules, follow bond conditions, and you're good to go, okay?
Okay, so we're good then. All right, yeah, I'll do whatever it takes, Pastor Jack. Listen to him. I just want to get a job, get out of this county, better my life.
I appreciate your making those statements and work with Pastor Jack, and we'll see you then, okay? We
All right,
are
thank you.
adjourned. Thank you.
Your Honor.
in Kansas, case entitled State of Kansas versus Benjamin Stiles. It's case number 2024 CR 274. Nika Cummings appears as defense counsel, Brett Sweeney on behalf of the state of Kansas. However, the defendant, Mr. Stiles, does not personally appear. This matter came before the court last on August 4 of 2025. At that time, the defendant pled guilty to possession of controlled substance, methamphetamine, a level 5 drug felony. A pre-sentence report was ordered. The defendant was specifically ordered by this court to comply with any and all assessments and to appear at the Judicial Center for sentencing.
I have never seen that court security person. I am so confused at the moment. How dare they? How dare they?
Subsequent to that, the court received a report from Chief CSO Sarah Wheeler, which reads as follows. This officer is requesting additional time to complete the pre-sentence investigation. Mr. Stiles never reported to this office to complete the required assessments for the pre-sentence investigation following his release from custody. This officer contacted his ISO in Sedgwick County, Jessica Smith, on October 1, 2025, and she reported that she is having issues with him reporting and that there is no recent LSCMI assessment complete. Please allow for additional time to complete the required pre-sentence investigation process submitted by Sarah M. Wheeler, Chief Court Services Officer. All right, Ms. Cummings, for the record, do you have any information for the court as to why your client, Mr. Stiles, is not at the Judicial Center ready to proceed further in his case?
I have no information, Your Honor. I tried to call his probation officer. She didn't call me back. I don't have a good number for him right now.
As the court recalls, Mr. Stiles was earlier placed on a no bond hold because he didn't appear in court when he was supposed to, due to the effectiveness of Ms. Cummings' advocacy. When this court took the plea on August the 4th, the court gave him another chance, gave him an opportunity with a reinstated bond, but set these conditions, none of which apparently that Mr. Stiles takes seriously and has any intention of complying with. This court, due to the defendant's failure to appear for this sentencing proceeding, the court will order bond forfeiture, a bench warrant issue for the arrest of Benjamin Stiles, with Benjamin Stiles to be held on a no bond hold pending further proceedings in the case. Once he's in custody, the court services officer should have access to complete the necessary assessments so that we can reschedule and eventually conduct sentencing at some future date. With that bond forfeiture bench warrant, no bond hold order now issued, Mr. Sweeney, is there anything else from your office's perspective that we need to address currently?
No, Your Honor.
Ms. Cummings, anything further at this time?
No, Your Honor.
All right, very well then. If there's nothing further in the Stiles matter, this proceeding will be in recess and the meeting may be ended for all.
Thank you.
Benjamin Stiles appears from the Butler County Detention Facility Zoom location. Nika Cummings as defense counsel. Brett Sweeney as prosecuting attorney on behalf of the state. This matter comes before the court at last for sentencing. Court noting that the defendant had appeared before this court on August the 4th of 2025.
He doesn't have enough hair to make a man bun. So instead, he turns himself into one of those little Norfin trolls. Yeah, I agree, Earl. I agree.
At that time, he pled guilty to count one, a possession charge, level 5 drug felony. All other counts were dismissed pursuant to plea agreement. A pre-sentence report was ordered, sentencing originally set for October the 7th. Docket notes from October the 7th indicate that the defendant did not appear. Court ordered a bond forfeiture bench warrant and no bond hold. The court also had noted at that time that that had been this defendant's second failure to appear. Eventually, the defendant was brought before another judge, and today's hearing was set. This court has received a completed pre-sentence investigation report compiled by Sarah Wheeler, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of the report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in that report?
No objection, Your Honor.
Is there any objection to the criminal history by the defense, Ms. Cummings?
No, Your Honor.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in this case this afternoon?
No, Your Honor.
Ms. Cummings, are you aware of any such legal reason?
No, Your Honor.
Mr. Stiles, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing this afternoon?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Ms. Cummings?
No, Your Honor.
All right. Are there any victims or members of a victim's family present who desires to address the court in relation to the Stiles sentencing? Court finds no such persons present on this meeting. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence, beginning with Brett Sweeney on behalf of the state of Kansas.
Thank you, Your Honor. Your Honor, there's just a sole count one. The state is recommending 20 months in Department of Corrections. Likewise, we're recommending the 20% good time and the 12-month post release that are listed on the face sheet of the PSI. We do believe it's accurate, 103 days of jail time credit. Your Honor, this is a case that where there was pre-sentencing evaluations that were obviously done, and he qualified for mandatory Senate Bill 123 treatment. That being the case, the state's recommending up to 18 months of community corrections probation. We would ask that all of the conditions that are listed within the PSI be adopted by the court, as they all appear to be appropriate. Some of the correspondence from Ms. Wheeler, who prepared the PSI for today's hearing, indicated that he was already on community corrections over in Sedgwick County. I'm not sure how far along he is in that, and I'm sure there will be some overlap if the court adopts Senate bill recommendations here today, but would just ask that he work with Butler County ISO supervisors if there's going to be a transfer and how that's going to work. As far as costs and fees that are being recommended by the state's not requesting a fine. That's part of the plea agreement. We would request the court costs in the matter, $300 payable towards Senate Bill 123 treatment, $400 payable towards a KBI laboratory report, corrections and supervision fees, and attorney's fees if the court finds those appropriate.
Very well. Thank you, Mr. Sweeney. Ms. Cummings, your recommendations regarding an appropriate sentence?
Your Honor, we are also asking the court to place him on probation. We would ask for the mitigated number of 18 months rather than the standard 20. However, we would like the court to know that yes, he is on community corrections already in Sedgwick County. And I pulled up those journal entries, And he had a probation violation there just recently. That was, and he has been placed back on probation. And so he did get a sanction. He served some jail time. And part of that was when he was in jail to get a new drug and alcohol evaluation in custody, which he said he did. So he's supposed to, when he gets out, he's supposed to go to intensive outpatient treatment at a facility that's right by 905 North Main, which is the Community Corrections Field Service place. So I'm not really sure the name of the treatment facility that he's in, but he tells me it's right by Community Corrections. He says this time what he thinks is going to be different is that they're going to start him on Suboxone, which will help with his cravings. And so he thinks that he'll have more success that way.
I hope so. But do you know how many people I know personally who have used Suboxone and just continued to use their, method of choice on top of it? A lot. It's kind of a problem.
He did, obviously, he failed to come to court. He said that he got very overwhelmed when he was originally released from jail. There were just so many conditions that he had to do, getting the job, getting into inpatient treatment, doing all the necessary things. And then he said that he just became overwhelmed. And so it's not a good excuse, but it's his excuse, and that's what was happening with him. So he doesn't want to go to prison, and he wants to get things right, and he wants to get his addiction in order and stop that. He has a lot of friends who have died from the fentanyl use, and he doesn't want to be one of those people. So, Your Honor, he does say that for the last 6 months when he wasn't in custody, he was working for Tree Branch Limb Care. And at least that's a job where the owner of that company will pick him up, because right now he doesn't have a driver's license. And so that's might be one of his problems. So we would ask for probation to be transferred to Wichita, but one of his problems is going to be transportation because he can't drive.
Ms. Cummings, are you appointed on this case or retained?
Appointed.
How much are your fees in the representation of this client?
I haven't added it all up, but not very much. Not very much.
Not very much.
I know that's not a good, well, I would ask that because he has so much right now, I don't think if I may ask him, since normally I'd whisper to him, but how much do you make per hour?
$15 an hour.
I would ask because he still has to pay, he told me he had to pay like over $2,000 just to get his driver's license back. And then with all these costs now, I would ask not to have him pay for the bids fee.
Very well, Ms. Cummings. At this time, the court will address the defendant, Benjamin Stiles, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present. Mr. Stiles?
No, sir, I don't.
Very well. Court will pronounce sentence in the case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of E, thus placing him in grid box 5 drug E. The court hereby sentences the defendant to a term of 22 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered but declines to impose a fine in this particular case. Mr. Stiles, somebody who doesn't show up for their felony sentencing always is something that's troublesome to this court. You had something that was more important, apparently, than showing up for your sentencing because you were so overwhelmed. Well, let me let you in on a little secret, Mr. Stiles. All of us at one point in our lives are overwhelmed. We're constantly facing challenges as people in society. So that is not an excuse for failing to show up for court. And here it's a 6-month delay from the time that you entered your plea before we get you before the court for sentencing. It makes me wonder that if you get overwhelmed and won't show up for something as important as your felony sentencing, are you even a good candidate for probation? Are you even a good candidate for a treatment program as the state sponsors in a Senate Bill 123 case? Well, probably lucky for you, Mr. Stiles, that's not a discretionary call that the court's going to make today, because this is a mandatory case for Senate Bill 123 due to the fact that you have a high probability of a substance abuse disorder as determined by your SASE, and that a high risk score on your LSCMI. This court mandatorily will at this time impose a sentence of up to 18 months in treatment as part of an up to 18-month initial term of community corrections probation.
Oh, you know Judge Ricky wouldn't have given that to him if he didn't have to.
Conditions of that probation will include reporting to an officer as directed, observing all laws. The defendant must obtain a Senate Bill 123 evaluation without delay and follow all recommendations for treatment or aftercare that are recommended by your provider. You shall not possess or consume alcohol or illegal drugs at your supervising officer's request, and at your own expense. You shall submit to random breath, blood, and urinalysis testing. Gain and maintain employment suitably throughout your probationary term. Perform any community service work that the Community Corrections Program may require. Notify your supervising officer of within 24 hours of any change of employment status, residence, telephone number, or email address. You shall have no contact with disreputable places or characters. Let me define what that means, Mr. Stiles. Anybody who would expose you to drugs, such as methamphetamine or fentanyl, is a disreputable character and person in this court's view. Further, anywhere where you could go where that offer might be made is a disreputable place. Now, there is one notable exception, Mr. Stiles, and that's treatment. Everybody in treatment probably has a drug problem. Certainly, the court wants you to attend all of those sessions. That's not the type of disreputable place which the court is referring to here. You shall submit your DNA to the KBI data bank and be responsible for the $200 cost of the test. Abide by any curfew restrictions imposed by your officer. Not have in your possession firearms or dangerous weapons. Community Corrections is authorized to require the defendant to meaningfully participate in the MRT program. And I do want to stress that the focal point here of this probation, Mr. Stiles, is rehabilitation, treatment, getting you free from drugs. If you don't take that seriously, you're going to be back before the court and you're going to be looking at more incarceration time, I assure you. Regarding financial assessments in the case, the court will assess a felony docket fee, felony probation fee, community corrections fee, $300 reimbursement for Senate Bill 123 purposes, $400 to the KBI laboratory, a bids application fee of $100. However, the court will waive all attorney fees that have been incurred in this case due to the defendant's financial posture. Court finds that making $15 an hour, the defendant working full-time should be able to systematically pay off these amounts without hardship over a period of time. Court will not require a payment from this defendant until April of the year 2026. At that point, the defendant is required to pay a minimum of $100 a month on his obligations until his amounts are paid in full. Again, $100 a month minimum starting with the calendar month of April 2026. Mr. Sweeney, I want to make sure that if there are any additional fees or expenses that the court needs to consider, that I go ahead and rule on that now. Are you aware of anything else?
No, Your Honor.
All right, I'll move on. Regarding the issue of jail time credit, the phase sheet indicates 103 days of accrued jail time credit, which the sentencing journal entry in this case should reflect. Mr. Stiles, at some point in the future, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek an expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant in Kansas may have the right to appeal their conviction to an appellate court having jurisdiction. And if a defendant is unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, Mr. Stiles, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. Mr. Stiles, I will remind you that there are prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. This court has no opposition to an orderly administrative transfer of probation to Sedgwick County if the current community corrections office in Butler County believes that to be appropriate. It might help facilitate the long-term success of this defendant, but the court considers that an administrative matter to be handled by community corrections. Speaking of that, Mr. Stiles, I have a community corrections officer on this meeting with us, Teresa Stanfill. I'm going to require you to, after we recess court, to stay on the Zoom meeting so that Ms. Stanfill can visit with you about what she expects from you. Now, I'm going to go ahead and release you from any hold in this case, Mr. Stiles, not necessarily because you've earned it, but because you've already served 103 days in jail, and I hope that the jail lesson's been learned by now. So I'm going to order you released on this case immediately and allow the sheriff's office a little time to get you processed out today, Mr. Stiles. And again,
Oh, what a burn. Judge Ricky for the win. Not necessarily because you've earned it, but because you sat 103 days, and I hope the lesson's been learned. We'll see. We'll see.
Ms. Stanfill will let you know what you need to do from there. Unless you have other holds. Do you have other holds right now, Mr. Stiles?
No, sir.
Good. Then follow Ms. Stanfill's directions after court. Mr. Sweeney, is there any other sentencing related matter which the court needs to address?
No, Your Honor. Thank you.
Ms. Cummings, is there anything further from your perspective that the court needs to address?
No, Your Honor. Thank you.
Mr. Stiles, you have any questions about the court sentencing orders?
No, sir.
All right. Again, we'll leave the Zoom meeting open after we recess to allow for a conference between Mr. Stiles and his community corrections officer. Ms. Cummings, you may, but are not required to be part of that session. That's up to you.
All right. Thank you.
If there's nothing further, the Benjamin Isaac Stiles matter will currently be in recess, and it's time the court will be in recess. And again, we'll leave the Zoom meeting open for the conferencing. All right, is this Donovan J. Campbell that's seated at the detention
Yes, Your Honor.
center location?
Yes, Your Honor.
Okay. It's the state of Kansas versus Donovan J. Campbell. It's case number 2024 CR 253. Chris Pate appears as defense counsel. Mr. Campbell from the jail Zoom location. Brett Sweeney on behalf of the state. One announcement, Mr. Pate, is made regarding preliminary hearing right.
Your Honor, Mr. Campbell is going to waive his preliminary hearing and move forward with a felony plea today.
Are we rushing this, Mr. Pate?
Your Honor, I did want to make a record on that. I went and had a good meeting with Mr. Campbell in the jail last week. At that time, I did not have a formal offer from Mr. Sweeney, but I did discuss with Mr. Campbell what offers might be and discussed sentencing guidelines, Senate bill, presumptive prison versus presumptive probation, border box, and things of those nature. Mr. Sweeney gave me an offer today, and I went in and discussed that with Mr. Campbell in a breakout room. But I do want to state on the record that we had a lengthy discussion about likely plea offers last week. So I think Mr. Campbell has received adequate advice from me to be able to proceed, but would ask the court inquire independently of him as to that.
All right, Mr. Pate, what is this purported plea agreement that's been reached?
It would be a guilty plea to count one, which is a level 5 possession of fentanyl, and it would be a dismissal of count 2, which is a class B paraphernalia.
Are there any agreements regarding sentencing recommendations?
Your Honor, I believe the state would just be recommending the presumptive sentence. I believe this may ultimately qualify for Senate bill. However, I believe Mr. Campbell is a B box based on a prior PSI that I reviewed. I believe his person felonies are low enough that he could still qualify for Senate bill, however.
All right, Mr. Sweeney, is there anything that you would add to Mr. Pate's statements?
No, Your Honor.
All right. All right, Mr. Campbell, this court is now informed that you intend to waive your right to a preliminary hearing and rather enter a plea of guilty and accept conviction for count 1 of your information, possession of fentanyl, a level 5 drug felony. Is that indeed your intention?
Yes, Your Honor.
All right. Mr. Campbell, I've got a number of questions I need to ask you regarding the taking of a felony plea. If there's any question asked of you that you do not understand, I will give you the opportunity to confer privately with your lawyer, Mr. Pate, at any stage to get more advice if you need it. Just let the court know if you need that time to confer, okay?
Yes, Your Honor.
State your full legal name for the record.
Donovan J. Campbell,
How old are you right now?
34.
Okay. What's the highest level of education that you've attained?
I've been at technical college.
Now, do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court here today?
No, Your Honor.
Have you ever been adjudged to be mentally ill?
No, Your Honor.
Are you currently under the influence of alcohol or any drug?
No, Your Honor.
Are you taking any type of prescription medication?
No, Your Honor.
Are you supposed to be taking mental health medications that you are not currently getting?
No, Your Honor.
So can you relate to this court that your mind is clear and that you have a full understanding of what's going on?
Yes, it is.
Okay. All right. Did you receive a copy of your charges in this case?
No, I have not.
Well, do you understand the nature of the charge of possession of fentanyl?
Yes, I do.
Okay. You understand that when you enter a plea of guilty, you are admitting that act charged by the state in count 1?
Yes, Your Honor.
Do you further understand that when you enter a plea of guilty, you're giving up any legal defenses that you might have had to that charge?
Yes, Your Honor.
Okay. Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Pate, and that you could present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, Your Honor.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described?
Yes, Your Honor.
Are you also aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, Your Honor.
You understand that by entering a plea of guilty, you waive your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes, Your Honor.
You understand that you have a right to appeal a guilty verdict when you have a trial?
Yes, Your Honor.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea.
Yes, Your Honor.
Now, are you aware of the possible sentence that could be imposed as a result of this guilty plea that you are attempting to make?
Yes, Your Honor.
On level 5 of the drug offense grid under the Kansas Sentencing Guidelines Act, in the most favorable criminal history category of I, you could receive as little as a 10-month sentence. In the worst criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. There's been some mention here that you may be as high as B on the grid. You understand that on level 5 drug in category B, the sentencing range would be 32 to 36 months in prison.
Yes, Your Honor.
You also understand that you could receive up to a $100,000 fine for this offense.
Yes, Your Honor.
Also, if you are indeed in drug level 5B, you would be presumptive prison in this case. And there's been some mention here that you might qualify for Senate Bill 123, which is a state-sponsored drug treatment program in which drug treatment or substance abuse treatment would be mandatory as part of what would generally be a community correction supervised probations for up to 18 months. Again, do you understand that that's what Senate Bill 123 is all about?
Yes, Your Honor.
And that there's no guarantee as you participate today that you will qualify for that?
Yes, Your Honor.
Okay. In addition to any fine that could be imposed, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims if any are owed as part of your sentencing orders?
Yes, Your Honor.
You also understand that as a direct consequence of this plea, you will be sentenced to a period of reporting probation, reporting parole, or post-release supervision, which generally will range somewhere between 12 and 60 months in duration. You understand that?
Yes, Your Honor.
All right. You also understand, Mr. Campbell, that special sentencing rules exist in the Kansas Sentencing Guidelines Act that could affect your eligibility for probation.
Yes, Your Honor.
Now, did you have an ample opportunity to fully discuss all of your legal and case-related matters with Mr. Pate before proceeding here today?
Yes, Your Honor.
You want any more time with him privately now before we go further?
No, Your Honor.
Are you satisfied with the advice and services that he has provided you?
Yes, I am.
Okay. Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, Your Honor.
You understand, Mr. Campbell, that if there have been any plea deals between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court shall consider them as recommendations, but is not bound by them. You understand that?
Yes, Your Honor.
So let me ask you, how do you formally plead to the charge in count 1, possession of fentanyl, a level 5 drug felony?
Guilty, Your Honor.
What did you do that would constitute this offense? First of all, okay, tell me when it happened.
It happened towards the beginning of last year. I was with somebody, they got pulled over. They had warrants. I had a couple of warrants out of Wichita, so they searched me and they found some fentanyl on me.
Okay. And you knew you were in possession of fentanyl at the time?
Yes, Your Honor.
Okay. According to the state's charging document, this took place about April 3 of 2024. Is that when you think it happened?
Yes, Your Honor.
Where did you get pulled over at?
I think it was in Augusta. Yeah.
Okay. And that's in Butler County, Kansas, isn't it?
Yes.
All right. So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for possession of fentanyl, a level 5 drug felony?
Yes, Your Honor.
All right. Mr. Pate, do you know of any legal reason why the court shouldn't accept your client's plea?
No, Your Honor.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
Mr. Campbell, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea of guilty at this time?
No, Your Honor.
Court will therefore accept the guilty plea made by defendant and finds that that plea is made voluntarily. He has an understanding of the nature of his charge and the consequences of his plea, and a factual basis for the plea does exist. Court finds him guilty and adjudges him therefore convicted of possession of fentanyl, a level 5 drug felony. Any other count of the information is dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to determine this defendant's criminal history, and the court will set an appropriate date for sentencing. Campbell, I wish I could just go ahead and sentence you now, get this over with, but that's not the way it works. A pre-sentence investigation and criminal history research needs to take place. We generally allow about 2 months for that to be done. Tuesday, December the 2nd at 3 in the afternoon, Mr. Pate.
And oh boy, does that pre-sentence investigation report need to be done.
December 2 at 3.
That would work, Your Honor.
Hearing no objection from the state, the court will set the sentencing in the Campbell matter for 3:00 p.m. Tuesday, December the 2nd. All right, Mr. Campbell, you very well may be asked to do one or more assessments to prepare for the sentencing, a risk needs assessment and a substance abuse evaluation of some kind. It is in your best interest to fully cooperate with those assessments and evaluations. In fact, the court's going to order you to do so that we can complete this sentencing on December the 2nd at 3:00 when scheduled. All right. Mr. Sweeney, are you aware of anything else we need to address here?
No, Your Honor.
Mr. Pate, are you aware of anything further that we need to address today?
Could we address the issue of bond, Your Honor?
You may.
Thank you. I believe Mr. Campbell is in custody on a $5,000 cash or surety bond in this matter. He reports to me he's been in custody since March of 2025. A great deal of that time was on a Sedgwick County case that he resolved. He's been placed on probation over there. It was for a criminal threat. I reviewed the PSI in that case, and it looked like what makes him a B box was the level 9 criminal threat. And then there were some person misdemeanor conversions out of Wichita Municipal Court. So those were the 2 person felony equivalents. So based on that, I think he would be eligible for Senate bill if he qualifies through the screening. I can tell the court, he reports he's been attending Substance Abuse Center of Kansas while in jail over there. I think there may be a recommendation for inpatient is what he's reported to me. I've not yet seen those records or anything, but he's been actively participating. He reports to me if he were to make bond, he would stay with Kathy and Clyde Lusk in Park City. He tells me he had confirmed that he could stay there with the Lusk family. I know this court doesn't typically grant OR bonds. I think it'd probably need to be 1,000 cash or surety or an OR for him to have any chance of getting out, but would ask the court consider that and possibly grant some type of bond reduction.
Are you aware that he's already had his bond cut in half once already?
I was not aware of that, Your Honor.
What's the state's position on this request?
Your Honor, I think it's appropriate where it's at. I was going to mention that it's already been reduced one time. Additionally, the state just has concerns that if it's lowered beyond a certain point, then it doesn't incentivize the bondsman enough to go and get said individual if they don't reappear, as opposed to just paying in the bond. So,
and the suggestion that's been made as part of the record of this proceeding that he could very well fall in a B box makes him presumptive prison, which I think definitely increases a a run risk, plus he doesn't appear to have Butler County ties. Mr. Campbell, you very well may be well-intentioned here, but the bond where set appears to be consistent with where it should be set in your case, and I'm not going to lower the bond any further. It's currently set at $5,000 cash or professional surety. That may be difficult for you to make, and you've handled yourself appropriately today, but the court's not inclined to lower that bond any further. It remains $5,000 cash or professional surety required. However, the court will also add a condition that if he does make that bond, he is required to stay and reside either in Butler or Sedgwick County, which certainly opens up the Park City residents. Mr. Campbell, I don't want you further away, and that you're restricted to the geographical locations of Sedgwick and or Butler County at all times. And then I would need you to appear, if you're not in custody, at the Butler County Judicial Center for your sentencing on the date that we've established, December 2 at 3 o'clock, and no other location. All right. Anything else, Mr. Pate?
No, Your Honor. Thank you.
All right. Then if there's nothing further, the Donovan Campbell matter will currently be in recess, and we'll move on to another matter on the docket. Court of Butler County, Kansas, case entitled State of Kansas versus Donovan J. Campbell. It's case number 2024 CR 253. Donovan Campbell appears from the Butler County Detention Facility Zoom location. Brett Sweeney appears for the state of Kansas. Chris Pate is defense counsel, separately from his client by Zoom. This matter comes before the court at this time for sentencing in the case. Court noting that the defendant appeared before this court on October the 6th of 2025. At that time, pled guilty to count 1, possession of fentanyl. The court set sentencing for today and ordered a pre-sentence investigation and report, which the court has now received, as compiled by Marcy Tarona's pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No, Your Honor.
Any objection by the defense? Mr. Pate?
Your Honor, I've reviewed the PSI with Mr. Campbell. We have no objection to the criminal history score of B, like boy.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score B, and the court will proceed further accordingly.
Ooh, so he did make B box. That's not good.
Mr. Sweeney, are you aware of any legal reason why sentence should not be pronounced in this case here this afternoon?
I know of none, Your Honor.
Mr. Pate, are you aware of any such legal reason?
I am not aware of any reason, Your Honor.
Mr. Campbell, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No, Your Honor.
Or proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence filed in this case or any other sentencing related motion to take up. Does the state have any such motions to pursue? I can't hear you, Mr. Sweeney.
I apologize, Your Honor. The state has no such motion. I am in receipt of a defense motion for, looks like downward or durational or dispositional departure.
I'm not aware of the content of that motion. When was it filed, Mr. Pate?
I'm looking at the certificate of service. It says November 25th.
Let me look. I'm going to ask my assistant to go ahead and forward that to me. I trust you wish to provide oral argument in support of your motion, Mr. Pate?
Yes, Your Honor.
You may proceed with that.
Thank you, Your Honor. And I'll just make all of my sentencing recommendations at this time. Mr. Campbell is a criminal history score B. That places him in the 5B drug grid box. That is a presumptive prison sentence. However, it's in a category that provides for Senate Bill 123 treatment if the court makes certain findings necessary for that. Those findings would be that there is a treatment program available within a reasonable amount of time, and such treatment program would be more effective in promoting offender reformation than a lengthy prison sentence. We would be asking the court to make that finding. Frankly, I'm not sure in this scenario if I'm required to file a downward departure motion with the Senate bill treatment, but I did anyway out of an abundance of caution. I can tell the court in the Senate bill assessment that was done and provided to everyone, it appears Mr. Campbell has a substantial drug problem that needs addressed. The recommendation that was provided for in that assessment was intermediate inpatient, followed by outpatient, then with a reintegration period. Mr. Campbell is very willing and actually pretty excited that he qualifies for that opportunity and would love an opportunity to participate in the inpatient treatment program as recommended. I would also note for the court, he's got a substantial period of incarceration. He's had about 9 consecutive months in custody between Sedgwick County and Butler County. He did get placed on probation on a felony case out of Sedgwick County and then was brought over to Butler on or about August 11th, which is the start date of the jail credit on our pre-sentence investigation. Mr. Campbell has made good use of his time in custody. As I said, we have Ashley Nelson present from Substance Abuse Center of Kansas. She's available to make a statement if the court will allow. I also provided a letter from Ms. Nelson via email to the court and counsel, letter dated November 4th of 2025. Mr. Campbell completed level 2 of the outpatient peer mentoring program while in custody. The letter goes into some of the details of what that program involved. For example, addressing and healing trauma-related issues, developing a sense of identity without the use of substances, practicing effective coping strategies for challenging life situation, identifying and overcoming personal barriers to long-term sobriety, and strengthening relapse prevention skills. He also, while in custody, completed a Getting Ahead While Getting Out program. I provided a letter from Ray Teal, president of Thrive Butler, outlining that program. So Mr. Campbell, I think, is more so than most people we see taken full advantage of everything available to him while in custody to set himself up for success. As I said, he's had now a 9-month period of forced sobriety. So if and when he does get out, he's got that sober time behind him. It sounds like there would be an inpatient bed available pretty quickly. But to the extent it would take a few days, I think Mr. Campbell would be willing to stay in jail until that bed is available. So he's going directly from one controlled environment to another. I would also note Mr. Campbell is a B-box in part due to person misdemeanor conversions. I understand that's the state of the law and how that's how those things get counted. But I think it's important to note that his only person felony was a level 9 criminal threat, which is the case he's on probation for from Sedgwick County at this time. I think another big factor here is Mr. Campbell has never received the benefit of Senate Bill 123 treatment. So this would be his first and maybe only opportunity to take advantage of that. And I think that program would highly increase his likelihood of not coming back into the criminal justice system, probably more so than just a lengthy prison sentence. Mr. Campbell has openly accepted responsibility for his actions with me since the beginning of this, resolved this matter in a very timely fashion. He's ready to move forward, hopeful that the court will grant him this chance at probation to get himself sober. Formally, it looks like he'd be entitled to 113 days jail credit. We would ask the court impose the standard number of 34 months with 20% good time and 12 months post-release. I would ask the court to make the necessary findings for Senate bill treatment and place him on probation for 18 months to complete treatment. In the alternative, if the court does not grant probation, we'd ask the court consider a durational departure to a shorter appropriate sentence. I think those are all the recommendations I would have.
Pate, here's what troubles the court. I note first that you've articulated you and your client's position well, but doesn't the court have to make a finding that the public would not be jeopardized by the granting of probation in this case?
Yes, I believe the court does, Your Honor.
Well, when you look at his criminal history with numerous stalking offenses, domestic battery, intimidation of a witness, all would make this court believe that he is a danger to society. How can the court make the finding under the facts and circumstances of this case? And let me add that his recent Sedgwick County conviction were crimes against persons.
Yeah. How can Mr. Pate claim that he only has one person crime? All of that sure sounded like people crimes.
Well, Your Honor, I think it just goes back to, like you see in a lot of these cases, that people's criminal behavior is a product of their drug use. And I think these behaviors were in large part due to his substance abuse. So I think it would probably benefit the community more to address those underlying problems so that a sober Donovan Campbell with the tools gained from this treatment, so that person can be in society rather than just a lengthy prison sentence where he probably wouldn't be able to avail himself of the same level and quality of treatment that he would get if the court adopts the Senate bill plan that's been put forward.
Very well. Next, I'll turn to the state's attorney, Mr. Swinney, and I'll ask, what is the state's position on this request?
Well, thank you, Your Honor. Your Honor, the state's position is pretty straightforward. In most of these cases, and in this case, the state's just arguing for the presumption, and would just note that obviously he's got enough criminal history to place him in a position where, you know, he is B-box, and this is placing him in a presumptive prison category. I obviously concede that it's a simple possession, albeit for fentanyl. And I don't know how interrelated some of his other criminal history is with his drug usage. But the state's recommendation is really just based on the legislative presumption here. I don't have any objection, obviously, and I know the court will take into consideration some of the pre-sentencing evaluations he's done and potential treatment options available to him. I would note that if the court does opt to go that route, and I do think it's probably appropriate. I've definitely seen it done where the departure motion is filed along with kind of as well as a finding or asking for a finding on the Senate bill treatment. If the court does go that option, I do think that assuming then substantial and compelling reasons are found by the court, then I think probably the Senate Bill 123 treatment, which is recommended in the PSI. If the court makes that alternative would be appropriate, and then all the subsequent costs and fees associated with that. Like the defendant and his counsel, I think that 113 days of jail time credit is appropriate, as is reflected by the PSI. We're also asking for the standard in mid-box 34 months, as well as the corresponding good time percentage and post-release supervision duration. Given what the state's recommendation is, I don't know that I have a lot of recommendations above and beyond that. I would note that there was a KBI laboratory report that was completed, and Mr. Pate is appointed.
Thank you. There's been a request made by defense counsel in this case to have Ashley Nelson address the court. Are you objecting to that, Mr. Sweeney?
I am not, Your Honor.
Ms. Nelson, you're apparently from the Substance Abuse Center of Kansas. Is that correct?
Yes, Your Honor.
What would your presentation to this court be?
I just wrote a letter to you, and I'll just read from it.
Well, okay, you can refer to it. I do have it before me. Is this the letter?
No, this is different from
Okay,
what you
go
have.
ahead.
Thank you for allowing me the opportunity to speak on behalf of Mr. Donovan Campbell. My name is Ashley Nelson. I'm a Kansas certified peer mentor, and I lead the substance abuse classes at the Butler County Jail. I also serve as a peer mentor for the Substance Abuse Center of Kansas here in El Dorado. I have had the privilege of working closely with Mr. Campbell over the past several months. Mr. Campbell voluntarily requested drug and alcohol assessment on August 13th of 2025, and since that time, he has attended every group session for the past 16 weeks, as well as multiple one-on-one sessions with me. During this period, we have worked extensively on key components of recovery, including self-awareness, relapse prevention planning, identifying triggers, developing healthy coping skills, and building a sober support network for his release. We have also discussed at length the importance of continuing treatment after incarceration, whether that be inpatient treatment, aftercare services, attending meetings, obtaining a sponsor, or living in a sober living house. Mr. Campbell has shown consistency and willingness not only to engage in these discussions, but to apply what he is learning. Over the past 4 months, I have observed a genuine internal shift in him. He has taken the initiative within his pod by organizing and participating in NA and AA meetings with other inmates. Early in our program, I assigned him an exercise requiring him to write a letter to himself from the perspective of a loved one who had lost him due to his addiction. This is a difficult assignment meant to help clients confront the reality of addiction and how close it brings them to death. The impact that it has on the people who care about them. This assignment had a profound emotional effect on Mr. Campbell. Since then, he has shown a clear commitment to choosing life, sobriety, and a future in which he is present for his children and able to contribute positively to society. I understand that Mr. Campbell has been approved for Senate Bill 123. Although he has completed 4 months of substance abuse groups incarcerated, I believe that continuing his progress in an inpatient treatment setting where he can more deeply address the connection between his addiction, mental health, and overall well-being would be far more beneficial than incarceration. In my professional opinion, Mr. Campbell has demonstrated sincerity, effort, and meaningful transformation. I believe he would greatly benefit from the opportunity to go to treatment in the community, and I support his placement in an inpatient service as he moves forward in his recovery. And that's all that I have, Your Honor. I would note that in my groups, Donovan has not at any time ever been aggressive, disrespectful. He's never missed a group due to being in trouble with the jail. So I know that on paper, he's a very different person sober than he is while using.
And there lies the rub. Because right now he's in a controlled environment. And yes, he has taken advantage of services that hopefully have helped him. I want nothing more than for everyone to beat their addiction. But the reality is, the probability of him relapsing is still pretty high. Even with him going to inpatient treatment, there's still the risk of him relapsing. He needs very, very intensive care along with mental health services because stalking is no joke. And he's a dangerous person. If he relapses and hurts someone, that's on you.
Ms. Nelson, is there a inpatient bed even available for him?
I don't know if there's one like immediately available, but I know that we could get him into one within 30 days.
And why does he need an inpatient bed at this time, having essentially been detoxed in the jail for a considerable period of months?
So detox in the jail is not considered clean time for inpatient treatment. They don't count it as clean time. I'm not a counselor, I'm a peer mentor. So going to inpatient treatment, he would work with a counselor, obviously learn some of the same skills that I've taught him in my groups. It would be 28 days where he would have be in a controlled environment. If inpatient was something that you didn't want him to do, outpatient is readily available immediately after being released from jail at the Substance Abuse Center of Kansas here in El Dorado.
All right, very well. Thank you for your statement to the court.
Mhm.
Right. Mr. Sweeney, do you need further opportunity to present your actual recommendations for sentencing in this case?
I don't believe that I do, Your Honor.
All right. Mr. Pate, do you have any further specific recommendations for the court?
No, Your Honor. Thank you.
All right. At this time, the court will address the defendant, Donovan Campbell, personally, and I'll ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court.
Yes, Your Honor. I'm aware that I've had a substance abuse issue for a majority of my life. It has affected my outlook and the way I feel internally and act externally in situations. And nothing in the world means more to me than my children. And I would just be grateful for an opportunity to get back out and work on myself so I can be fully present for them.
And where would you be residing if you got out?
Well, I'm currently on probation in Wichita. So whichever office would work with me and maybe transfer to one or the other, probably where I reside, either Wichita or El Dorado. I'm assuming that I'm going to be going to treatment if I do go to treatment in Wichita. So I'd probably do the follow-up, the reintegration program, which I'm not fully aware of what that is, what that entails. Probably do that in Wichita if I do go to treatment there. And I was thinking about probably moving back to El Dorado because it's where my two oldest children reside.
Very well. What type of work would you be able to do?
Fencing, roofing, siding, window foundation work, a lot of work like that. I was wanting to go back to school. I got sheet metal work. I was wanting to go back to school though for HVAC, get my HVAC certification. I got a buddy down here who works in HVAC. He said he can get me a job working here in El Dorado. Started as an apprentice.
Anything further, Mr. Campbell?
No, I think that's about it, Your Honor.
All right. Court does want to make it so fully familiar with the motion that's been placed before the court today that was referred to earlier by Mr. Pate. We're going to take a brief recess, and this will be relatively short, folks, so please stay with the meeting. I will be back very shortly. We'll pause the proceeding at this time. Mandy, could I just have your assurance that we're still recording and broadcasting?
Yes, Judge.
Thank you. Court resumes proceedings in State versus Donovan J. Campbell, case number 24 CR 253. Counsel for each side and the defendant appearing as before. Following the opportunity to review the departure motion, which is currently before the court will proceed to sentencing in the case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of possession of fentanyl, a severity level 5 drug, non-person felony in which the defendant has a criminal history score of B, thus placing him in grid box 5 drug B. The court hereby sentences the defendant to the aggravated term of 36 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Court does find that in grid box 5 drug B, this is generally a presumptive prison case. Court has considered the optional non-prison sanction that statutory law allows. However, this court cannot, under the facts and circumstances of this case, grant that exception, as the court cannot find that the public safety would not be jeopardized by the granting of probation in this case, given the recent history of this defendant committing violent crimes. With that said, the court has also considered the motion for departure. Obviously, for the court to have made the original finding under the statutory exception, departure is not necessary. Mr. Pate, in due course, has filed a motion for a dispositional departure in this case. Quite frankly, Mr. Campbell, the court's worried about you. You've done a wonderful job of conducting yourself while a jail inmate, but if you were out in the community, would you just backslide right back into the lifestyle that you've had before? Drug use, violent behavior, a lack of personal accountability, or do you mean it? Do you really want to make bona fide change? Do you really want to have a life where you're not locked up?
Yes, Your Honor, I do. I just turned 35 a few days ago. I'm at a point in my life where I can't go back. I can't make any more mistakes, you know, not in my life, not in my children's lives. I do mean it. I do have a probation in Wichita that I have too, another sentence over my head there. So if I make a mistake, it's gonna be a severe one. And I can't afford those mistakes anymore. Not in my life, not in my children's lives. So.
Well, Mr. Campbell, when I posed my remarks as a question, I didn't really expect an answer.
No.
The remarks you've made, I would expect from someone in your situation to promise the court that you'll do this and you'll do that and that you'll follow through this time and that you've really realized just what path you're on and you want to change it. That's actually not that unusual, Mr. Campbell. What the court has to determine is, do you really mean it? And are you worth the risk of putting you back into the community at this time? This time, the court finds that this defendant has embraced the opportunity for treatment and drug abuse rehabilitation, that he successfully participated in jail-based programming, and ultimately, successful participation in community-based treatment is more likely to ward off further offender recidivism than the presumptive prison term in the case. While this court considers this to be a very close call, Mr. Campbell, the court's going to grant a dispositional departure in this case to probation. But the court is expressly, as part of this record, doing this as part of a dispositional departure. And you'll also note, Mr. Campbell, I've given you the aggravated sentence in this case. If you don't mean what you say here today, you're facing the aggravated sentence, not a standard sentence, not a mitigated sentence, but an aggravated sentence. And I think the facts of your case and your situation merit an aggravated sentence in the case. But however, if you mean it and you're successful in the community, Mr. Campbell, then the court's going to be glad I gave you this opportunity. Conditions of probation will include observing all laws, reporting to an officer as directed. You shall not possess or consume alcohol or illegal drugs while on probation. At your supervising officer's request and at your own expense, you shall submit to random breath, blood, and urinalysis testing. Perform community service work pursuant to any program requirements. Gain and maintain employment successfully throughout your probationary term. Notify your supervising officer of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place. You shall have no contact with any co-defendant. Abide by any curfew or travel restrictions imposed by your supervising officer.
I hope this guy is genuine. I hope he's successful. I truly do. For him, for his children, and for the community. I genuinely want the best for him and for everybody. Unfortunately, I feel as if his remarks were so rehearsed, as if he was programmed to say them. And that doesn't give me a whole lot of faith. Usually, it's when people have the passion about their sobriety. Those are the ones I feel I can take seriously. He just felt like he was reading a script.
You shall not have in your possession firearms or dangerous weapons. You shall not associate with any disreputable characters or places. And let me tell you what I think that means, Mr. Campbell. Disreputable places is anywhere you can get drugs. Disreputable people is anyone who can get you drugs. And of course, we could go a little bit broader than that, but I think in your case, that's the court's expectation. You shall complete Senate Bill 123 treatment and follow all recommendations. And I trust Ms. Toronis and Ms. Stanfield, who's the two probation officers on this meeting, that due to the court's granting of the departure, he still would be Senate Bill 123 eligible?
That is correct, Your Honor.
Teresa, do you agree?
Yes, I do.
All right. The probation period in this case would be up to 18 months. The defendant, of course, is required to successfully participate in a drug abuse treatment program under the auspices of Senate Bill 123 and follow all aftercare recommendations of the provider. This court's in no position to be able to determine if inpatient or outpatient treatment is the most appropriate manner for him to seek treatment. I think that's due to the fact that the court's of the belief that he has been in a successful period of being free from drugs. He wouldn't appear to need immediate detoxification. I'm also aware that there's a limitation on the availability of inpatient beds. However, whatever your providers believe you need, Mr. Campbell, I'm going to expect you to do. Obviously, the employment requirement would be relaxed at any time you're in inpatient treatment. But again, I'll leave that to someone like Ms. Nelson and her group to determine what's the most appropriate for you at this time. The court deems that community corrections is appropriate due to the court's granting of the dispositional departure from a presumptive prison sentence, and also because of the Senate Bill 123 overlay in this case. I'll also note that this defendant has scored high on the LSCMI risk needs assessment, And he also was determined on the SASE to have a high probability of a substance abuse disorder. I didn't say this before. I want to make sure I repeat it. Community Corrections is authorized to require this defendant to meaningfully participate in the MRT program. The court will assess $400 restitution to the KBI, a $193 felony docket fee, a community corrections fee, correctional supervision fee. However, the court, under these circumstances, are going to waive any bids assessments that otherwise might be due, given the long-term incarceration status this defendant has had. And the court wants him to focus at this point on his treatment and rehabilitation rather than worry about paying back bids for his legal fees, though Mr. Paid services obviously have been quite valuable to this defendant. Court does grant this defendant 113 days jail time credit. I do want to state for the record, Mr. Campbell, the fact that you've been locked up for the last 4 months has been a factor in the court's decision to give you another chance. If there's a lesson to be learned by long-term incarceration, I hope you've learned it by now. Despite the programming that's been brought into the jail, I think you might even agree with me that county jail time is some of the hardest time you can do.
Yeah.
And I would think you wouldn't want to go back to it.
No.
So at least as far as this case is concerned, I'm going to order that he be released at this time. I don't think I can hold him any longer on a felony since he's already served more than 60 days in the county jail. So I'm going to order him to be immediately released. And quite frankly, it's cold outside, Mr. Campbell. I hope you have a place to go.
Yeah, well,
somebody who can pick you up and give you a place to stay.
Yeah, in Park City, yes.
All right. You're going to need to make sure that your community corrections officer and maybe even Ms. Nelson know exactly where you're going to be if they don't already.
Your Honor, can I say something?
Yes.
Donovan, upon your release, you're supposed to report to SAC within 48 hours so we can get you going, whether that's inpatient or outpatient.
Yes.
Where is that reporting site?
405 North Main in El Dorado.
Are you familiar with that, Mr. Campbell?
Yes, sir.
All right. Court so orders that you comply with that request from Ms. Nelson.
Thank you, Your Honor.
All right. Some point in the future, Mr. Campbell, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant in Kansas has the right to appeal their conviction to an appellate court having jurisdiction. If they're unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, Mr. Campbell, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. This court is unable to make a determination at this time as to a minimum amount that he can pay. I just don't have enough information to be able to make that determination, but you do need to pay down on this case, Mr. Campbell. When you get to working, you need to start paying something each and every month until you get your case paid off. Just one of the many implications of this felony behavior. And I truly hope, Mr. Campbell, that you never are even tempted to touch that horrible drug of fentanyl ever again. All right, I'm going to look at my notes from this sentencing. I am going to make an order at this time that the court is going to give this defendant 6 months to pay off his case. The case is not to be sent to collections for 6 months from today's date. If he doesn't have his case paid off in the end of that 6-month period, the court would authorize that the entire remaining amount becomes due, payable, and collectible, which means it can be sent to a collection agency after that 6-month period. So I know you've got a lot of things you need to treat as priorities, Mr. Campbell, but you need to get this case paid off. They're relatively modest amounts, and I have no doubt that if you put your mind to it and you're working, that you should be able to do it. All right, Mr. Sweeney, we've covered a lot of ground here. Do you need any clarification regarding the court sentencing orders?
Your Honor, did the court make a determination on $300 payable towards evaluation and treatment on the Senate bill?
Yes, the court will be assessing that as well. That $300 assessment to pay toward the Senate Bill 123 program. Thank you, Mr. Sweeney. That was the intention of the court. Mr. Pate, are you aware of other sentencing related matters that the court has not yet taken up?
Not at this time, Your Honor.
Ms. Stanfield, as the representative here from Community Corrections, do you need any further clarification regarding the court's orders?
No, Your Honor, if I could just meet with him after the court hearing to get information.
Okay, we can accommodate that. Importantly, Mr. Campbell, do you have any questions about the court's rulings and sentencing orders made here today?
No, Your Honor.
Okay, just so you leave here, Mr. Campbell, with this thought. You've been given a chance, one chance. Do not leave here today with the idea that you may get multiple opportunities to fail on your probation without doing your prison time. I think that would be a big mistake on your part. If you can just maintain the attitude and the direction that you have right now, you're going to successfully complete this. But you can't backslide, you can't relapse. In your case, the implication would be prison. Good luck, Donovan. I really hope that you're successful on this.
Thank you, Your Honor.
You're welcome. It's up to you now. If there's nothing further, the Donovan J. Campbell matter will be in recess. We'll leave the Zoom meeting open so that Ms. Stanfield can confer briefly with Mr. Campbell. Follow her directions, Mr. Campbell.
Yes, thank you, Your Honor.
Court is in recess.
I had to take Jim's advice and put Billy in community corrections right down there. Very, very rarely used. But in this case, it was a necessity. I was quite worried that they were going to come up on the desk. It was like one of those cartoon, balls of dust and dirt and legs and lightning bolts coming out. And a whole lot of ramming. So, yeah, Tiny Kitten is currently up on the head of my bed, hiding. And Earl is kind of in between them, standing guard. And Billy, I'm sorry, Donald. Donald's suggestion. I only saw it. I saw it very briefly. And then I was like, oh, that's not a bad idea. I have to go. Yes. Donald's suggestion. Yes, I will play the Mighty Metheny. I will put the Mighty Metheny on. Ava, back it up. I had to let Ava out too. All right, hold on. Let me. Video file. Oh, hold on. I had to take this one down. And then.
Drives her house with her loudest touch. thoughts are tired turning. Mailman has you waves hello. Don't mind me, I'm clean as snow. Neighbors whisper and lock the door, 'cause here comes Mighty Bethany once more. She's got tender plans before the door. She's either cooking or running a corn. She's Mighty Bethany. Still awake and follow through. When the streets goes dark and the night gets quiet, and the night of the last screams, don't even try it. She's Mighty Bethany. Still awake and follow through.
All right, we've got that one. And now,
She packs her house with love and stash. She stays stuck for days until she crashes. The neighbors speak, unlock their doors when a mighty Bethany comes outdoors. She's got 10 ideas before the dawn, half are gone before they outrun. Coffee's cold, her eyes still shine. She's a one-woman freak in assembly line. Vacuum running, toast is burning, every thought's a tire turning. Mailman Heights, she waves hello.
Don't mind me, I'm Queen Snow.
From 0 to 60, she's always in cheer. The wildest woman you'll ever hear. When the lights go out and the street gets quiet, she's still going a mad riot. She's mighty Bethany, still awake at 4:03. Vacuum running, toast is burning, every thought's a tire turning. Mailman Heights, she waves hello.
Don't mind me, I'm Queen Snow.
Neighbors whisper, lock the door, 'cause here comes Mighty Bethany once more. She's got 10 new plans before the dawn. She's either cooking or running a con. Coffee's cold, her grin's still wide. She's a cyclone on a sleep inside. She's mighty Bethany, still awake at 4:03. When the street goes dark and the night gets quiet, her maniac love screams, don't even try it. She's mighty Bethany, still awake at 4:03. She's mighty Bethany, still awake at 4:03. Woo!
oh, I wrote them. Well, to be fair, I wrote one, but when I had it made, it wasn't exactly what I had wanted, and so I hired someone else to make the second version. I have a video of Earl licking toasters. I'll be honest, I don't even know what a polka is. I don't know what a polka sounds like. It's not my genre. Oh, Ava, you are so spoiled. After this, I'm going to have to put these little kibble powders on top of your food. That's all that's left in here is just a little kibble powder in this one. A couple little scraps. All right. I have I have a friend who I guess they won some polka dance concert thingy. I don't know. It was a big thing for them. Not my thing. Ava, jeez Louise. No, that's okay. I'm good. I have one more, Ricky FTC. Yeah, so after this will be the last one, but one more. Stop it, Billy. Oh boy. He's moving litter, guys. That's a bad sign. That's a bad sign for me.
State of Kansas versus Austin Stuber, case number 2025 CR 201. Mr. Stuber appears from the Butler County Detention Facility Zoom location. Cheryl Pierce on behalf of the state of Kansas. Chris Pate appears as defense counsel. This matter was scheduled to come before the court today for evidentiary preliminary hearing. Are there any announcements to be made?
Your Honor, we've reached a plea agreement. Mr. Stuber will plead no contest to count 1, possession of methamphetamine, level 5 drug felony. State will dismiss counts 2, 3, 4, and 5. I believe there's going to be a special rule that requires this to be consecutive to another case, and that's really the entirety of the agreement.
All right, Ms. Pierce, if you could go ahead and come on the Zoom meeting fully. You're only partially visible.
I'm sorry, Judge. I got a new computer and it's
Okay.
not quite set up yet. Sorry.
That's
Is that
better.
better?
Yes.
He looks like a skinny, untattooed Danny Trejo.
Okay.
Do you agree with what's been announced regarding a plea agreement in this case?
Yes, Your Honor.
All right. Most importantly, Mr. Stuber, it's the court's understanding that you're waiving a preliminary hearing today and rather accepting conviction by entering a no contest plea to count 1, possession of methamphetamine, a level 5 drug felony in return for dismissal of other counts. Is that what you intend to do?
Yes, Your Honor.
All right. Well, I've got a number of questions I need to ask you regarding the taking of a felony plea. If there's anything you don't understand, I'll give you the opportunity to confer privately with your lawyer at any point. Just let the court know if you need that opportunity to get further advice. Okay?
Understood, Your Honor.
State your full legal name for the record.
Austin Van Stuber.
And how old are you right now?
36.
What's the highest level of education that you've attained?
GED.
Now, do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No, Your Honor.
Have you ever been adjudged to be mentally ill?
No, Your Honor.
Are you currently under the influence of alcohol or any drug?
No, Your Honor.
Are you currently taking any type of prescription medication?
No, Your Honor.
Okay. Are you supposed to be taking any mental health meds that you are not currently getting?
No, Your Honor.
So, as you sit today, Mr. Stuber, do you believe your mind is clear and that you have a full understanding of what's going on here in court?
Yes, Your Honor.
Now, do you understand the nature of the charge of possession of methamphetamine?
Yes, Your Honor.
You understand that when you enter a plea of no contest, you are not necessarily admitting that you committed this act, but you're also not contesting that you be convicted just the same. Do you understand that?
Yes, Your Honor, I do.
All right. You further understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to that charge.
Yes, Your Honor.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Pate, and that at your trial, you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
Yes, Your Honor.
You understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described?
Yes, Your Honor.
Are you also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, Your Honor.
Understand that when you enter a plea of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes, Your Honor, I do.
Now, you understand you have a right to appeal a guilty verdict if you have a trial.
Yes, Your Honor.
You further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgment of conviction after you enter such a plea.
Yes, Your Honor, I understand.
Now, are you aware of the possible penalties that could be imposed as a result of this no contest plea that you're attempting to make?
Yes, Your Honor.
Okay, well, let's go over those. This would be a level 5 crime under the drug offense grid under the Kansas Sentencing Guidelines Act. In the most favorable criminal history category of I, you could receive as little as a 10-month sentence. However, in the worst criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. As you sit today, we do not know with certainty what your criminal history is. You better than anyone else here really should know what your own criminal record looks like. But
Yes,
that
I
will
do.
be researched by the Court Services Department, and based on the outcome of their research as of the date of sentencing, that determines where you fall along the level 5 drug line, and then you'll be sentenced accordingly. Do you understand that?
Yes, Your Honor.
Mr. Stuber, you need to understand that if at sentencing you have a person felony on your record, you will be presumptive prison in this case.
I understand, Your Honor.
All right. You also understand that you could receive up to a $100,000 fine for this offense?
Yes, Your Honor, I do understand.
Did the concept of Senate Bill 123 get discussed with you? Senate Bill 123 is a state-sponsored substance abuse treatment program which would be mandatory for some offenders. I do not know if you would qualify for the Senate Bill 123 program or not. If you do, this would be a mandatory component of your sentence that you be in a substance abuse treatment program for up to 18 months. Do you understand that?
Yes, Your Honor.
Okay. In addition to any fines that could be imposed, are you aware that you could be assessed and be required to pay certain costs, including reimbursement of legal fees and expenses, and restitution of victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
Mr. Stewart, do you understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing?
Yes, Your Honor.
You understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, Your Honor.
You also understand that the Kansas Sentencing Guidelines Act is a whole book of sentencing rules and laws. Do you understand that if any special rules, which I think has already been alluded to here, apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence? You understand that?
Yes, Your Honor.
Now, have you had an ample opportunity to discuss fully legal matters like that with your attorney, Mr. Pate, before proceeding here today?
Yes, Your Honor.
Want any more time with him now before we go further?
No, Your Honor, I'm fine. Thank you.
All right. Now, are you satisfied with the services and advice given to you by Mr. Pate?
Yes.
All right. Now, this no contest plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, Your Honor.
Okay. Is there anything that you thought was part of the plea agreement that hasn't been accurately discussed on the record here today?
No, Your Honor.
Now, Mr. Stewart, do you understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. You understand that?
Yes, Your Honor, I understand.
All right. So how do you plead formally to the charge in count 1, possession of methamphetamine, a level 5 drug felony?
No contest, Your Honor.
I'll ask the state to provide a concise statement of factual basis for that offense.
Thank you, Your Honor. On April the 29th of 2025, a law enforcement officer with Butler County Sheriff's Department, Deputy Baraka, observed a gray 2007 Toyota Urus traveling southbound on the left lane in the 200 block of North Andover in Andover, Kansas. The Toyota merged into the right lane without the use of a turn signal. At that time, another vehicle was entering the right lane. The Toyota nearly struck the other vehicle and swerved around it. A traffic stop was conducted. The operator of the Toyota was identified as the defendant. There was a driver's license that had been revoked. Mr. Van Stuber's driver's license had been revoked.
Did he keep it in the Toyota? If she says Toyota one more time, I might just lose my mind a little bit. Lady, you can't convince me you've never heard of a Toyota. It can't possibly be spelled in a way that you would think it's pronounced Toyota. Reading comprehension, level 1.
At the time that officer approached the Toyota, Miss Austin was observed reaching under the front seat and claimed to be reaching for insurance documents. The defendant, Austin Van Stuber, was asked to step out of the vehicle and placed under arrest. At that time, there was also a search conducted of the vehicle. Located was a black magnetic box under the front passenger seat in the same area where Austin was observed reaching. That black box was recognized as one commonly used to conceal illegal substances. Inside the box was discovered a small smoking pipe with white crystalline residue and a clear baggie containing a white crystalline substance. The box had an orange and red sticker on it with the image appearing to be a bearded male with sunglasses with a marijuana leaf. That same sticker was identical to one that was contained on Austin's wallet as well. This substance was sent to KBI for testing and it was confirmed to be methamphetamine, Your Honor. I have
Very
nothing
well.
else.
All right, so Mr. Stuber, do you now enter a plea of no contest and accept conviction for that possession of methamphetamine charge freely, knowingly, and voluntarily?
Yes, Your Honor, I do.
All right. Ms. Pierce, do you know of any legal reason why the court should not accept this defendant's plea?
No, Your Honor.
Mr. Pate, are you aware of any such legal reason?
No, Your Honor.
All right, Mr. Stuber, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea of no contest this morning?
No, Your Honor.
Court will accept the no contest plea made by this defendant and finds that that plea is made voluntarily. Mr. Stuber has an understanding of the nature of his charge and the consequences of his plea, and a factual basis for the charge does exist. The court finds the defendant guilty and adjudges him therefore convicted of the level 5 drug felony crime of possession of methamphetamine. All other counts of the information are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine this defendant's criminal history, and the court will set an appropriate date for sentencing. I have a notation on the docket sheet that Mr. Stuber may be in Department of Corrections custody at this point. Is that correct, Mr. Pate?
Your Honor, there was another case that his probation got revoked on, so he is on that matter.
All right. Do we anticipate he's going to be transported to a Department of Corrections facility very soon?
Mr. Stuber, do you know?
Yes, I was talking to them and they said that they were just trying to get this case fast tracked so I could get up to the Hill. And that's I mean, I know what I did and I know what I did was wrong and that's why I'm admitting no contest and I'm trying to get up to the Hill so I can get my stuff done and get into a PI job, Your Honor.
Those little hide key boxes, great for geocaching. Very poor choices for hiding your drugs in your Toyota.
Okay. Well, we can conduct the sentencing from a DOC facility if we need to,
Okay.
but I'm gonna have to set the sentencing about 2 months out. I'll let the sheriff's office and Department of Corrections work out where you're going to be housed between now and then. So we're going to be looking at an early December date. Pate, what would your availability be Tuesday, December the 2nd at 3 o'clock?
Judge, most correctional facilities won't go past 2.
All right, let's look at 9 o'clock that morning, Mr. Pate.
That'll work.
All right. Trusting prosecutor's office will be able to have a representative there. I will set the Stuber sentencing for 9 o'clock a.m. on Tuesday, December the 2nd. Obviously, Mr. Stuber will need to be with us by Zoom at that time from whatever appropriate facility would be involved with him at that time. Tuesday, December 2nd, 9 o'clock for sentencing in the case. If there are any pre-sentence assessments, Mr. Stuber, you'll need to cooperate with those. It's in your best interest to do so. So if you're approached by a probation officer and they're wanting to do some sort of risk needs or substance abuse assessment, you'll need to fully cooperate with that, okay?
Yes, Your Honor.
All right, so December 2nd, 9 o'clock a.m. for sentencing in the Stuber case.
Thank you, Your Honor.
All right, Ms. Pierce, is there anything further we need to address regarding the Stuber case at this point?
No, Your Honor.
Mr. Pate, anything further?
No, Your Honor. Thank you.
Do you have any questions or concerns to address the court about at this time, Mr. Stuber?
No, Your Honor.
Well, you've handled yourself appropriately,
Thank you.
and we'll see you December 2nd at 9 o'clock for the completion of your sentencing in your case.
Thank you, Your Honor. Have a good day.
You too. If there's nothing further, the Austin Stuber matter will be in recess, and this meeting may be ended for. And I believe that person's in place at the jail Zoom location. Court will call at this time State of Kansas versus Austin Van Stuber, case number 2025 CR 201. Mr. Stuber appears at the Butler County Detention Facility Zoom location. Brett Sweeney for the State of Kansas. Chris Pate is defense counsel. This matter comes before the court at this time for sentencing. Court's docket notes indicate that this defendant appeared before this court on October the 6th of 2025. At that time, the defendant pled no contest to count 1, possession of methamphetamine, a level 5 drug felony. A pre-sentence report was ordered, sentencing set for today. The court has received a completed pre-sentence investigation report compiled by Tony Bauer, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No objection, Your Honor.
Any objection by the defense, Mr. Pate?
No, Your Honor. I've reviewed the criminal history score with Mr. Stuber, and we do not have an objection.
The court will adopt the criminal history score as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in the Stuber case this morning?
I do not, Your Honor.
Mr. Pate, are you aware of any such legal reason?
No, Your Honor.
Mr. Stuber, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing here today?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up at this time. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Pate?
No, Your Honor.
Are there any victims or members of a victim's family present who desires to address the court in relation to the Stuber sentencing? No such persons appear, so that at this time the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Stuber, beginning with Brett Sweeney on behalf of the state of Kansas.
Thank you, Your Honor. Your Honor, the state is requesting and recommending rather the standard mid-box 20 months in Department of Corrections. That would include the 20% good time percentage as well as the 12-month post-release supervision duration. As far as jail time credit goes, he has been in, and I believe still in on this case with a hold. My calculations in contact with the jail put him at 115 days of jail time credit. So, quite a bit more than what the PSI has, at least the one in front of me. He
Did you
is.
see the explanation in the pre-sentence report, Mr. Sweeney? Apparently, he's been ordered to KDOC in another case as of September 5.
And I knew he was ordered to KDOC as of September 5. That I think triggers an analysis under existing case law that's out there. And I still think that maybe he would be given credit for that 115 days. But I don't know. And I'll let Mr. Pate speak to that too. But in full candor, I think I have to just raise that. And I guess it would also maybe depend on how the court runs this case, whether it runs it consecutive or concurrent. I'll let Mr. Pate speak to that as well. But I do think that is an issue. He is in KDO. There is the KDOC commitment, and I says that that's for 22 months. He's presumptive probation in this case. So I don't know how the court wants to deal with that. I mean, obviously, I think the court has to put him on probation first, and then maybe there has to be an analysis beyond that about how long maybe we want to wait before we do a revocation. But if he is placed on probation, I think that all the conditions that are within the PSI report are appropriate. He's got one of the more interesting criminal histories I think that I've ever seen, with so many drug convictions that looks like they were all adjudicated like on the same day in 2011. It's very interesting. But as far as costs and fines associated with the case go, Your Honor, the state's not requesting a fine. That was part of the plea agreement. We are requesting the court costs in the matter. KBI lab fees, lab reports were completed. If the court does place him on probation, we're asking for community corrections and supervision fees, attorneys and bids fees if they're appropriate. And then we would ask for this case to run consecutive. I would note there's a special rule. We would ask for this case to run consecutive, and I think it's to that KDOC case that he's been revoked on, which is the 24 CR 17.
Mr. Sweeney, because of the application of the special rule that this crime was committed while he was apparently on probation for another felony, this wouldn't necessarily be a presumptive probation case. The court could invoke the special rule and send him to prison on this case without any further finding. Would you agree?
I would agree with that. I would tell the court that, normally it's the state's recommendation in these situations, and I think it was consistent in this case as well, that the state wouldn't necessarily or recommend the discretionary special rule. So, and I think in full disclosure, I have to let the court know that was part of the plea agreement. Although I would certainly admit that his commitment on the other Butler County DOC case does complicate the matter with respect to whether or not he's going to be able to complete probation with a 22-month commitment date on the other Butler County 24 case.
Okay. Well, we're talking about Butler case 24 CR 17, are we not?
That's correct, Your Honor.
All right. All right, Mr. Pate, again, interesting set of legal circumstances here. So what is your recommendation regarding an appropriate sentence?
Your Honor, our recommendation in this matter is that the court follow the presumption and place Mr. Stuber on probation. I believe it'd be for an initial term of 12 months. He's not eligible for Senate Bill 123 because of prior criminal history. I think this would have to be consecutive under the special rule. And obviously, as the courts noted, there is the option to impose prison. But like the state, we are not requesting that. I did not represent Mr. Stuber on the other case, but it's my understanding, and this is just based on discussions with Mr. Stuber, that with all the credit for time served on that case, potential good time and things of those nature, that he should be released from KDOC on that case in less than 12 months. So I think we're in a situation here where he could foreseeably complete a probation program. He's not going to be incarcerated for multiple years, or it'd just be impossible to do so. As to the jail credit, the PSI notes the 26 days. Depending on what was ordered in the other case, unfortunately, I think that's correct. We're all aware of the Irvin case, which kind of changed the rules on credit for time served, but then 216615 was modified after Irvin, and then it's section A2 that deals with that states that he shall not be considered incarcerated for any time that's awarded as credit in another case. So while I would love for him to get as much jail credit as possible, I think I've got to make the court aware of what my view of the law is, and I don't think that would be awarded here, assuming he's getting credit in the other case, which I think he probably is, and that's probably what gets him down to having less than 12 months to do. Mr. Stuber is, you can tell from the criminal history, he's got a drug issue. He recognizes that. He's been incarcerated now in some way, shape, or form since August 11th. He's going to be in for quite a while longer. So he's going to have a period of forced sobriety. I think he is serious about getting sober. I know those have been the discussions that I've had with him, that is definitely something he's going to do. I believe he's been looking into sober living facilities upon his release.
It would be more unique if you didn't have a conversation with him about his sobriety. Everyone says they're going to get sober when they're in jail. Everyone says they're going to stay sober when they get out. I have not heard an inmate once say, "Oh, nope, the second that I get released, Your Honor, I'm going to head straight for the corner. Straight to that corner RX pharmacy." No, that's not a thing.
So I don't think there's any prior person felonies here, as noted by the criminal history of E. As we've said, this is a presumptive probation case, but for the discretionary special rule, we would ask the court, give him that opportunity at probation, given that he'll be out in less than a year. Obviously, an extension of probation may be necessary depending on what conditions are imposed, and we would certainly understand it if that occurred down the road.
Well, I think a question to the community corrections officer on this meeting might be appropriate. Ms. Ashenfelter?
Yes, Your Honor.
So if this court were to follow Mr. Pate's suggestion and place Mr. Stuber on probation in this case, even though he's going off to prison, how is a case like that handled in your office?
Your Honor, if that occurs, he would remain on probation until he gets out of DOC. The only issue that comes with that is if he's going to expire. by that time, we would have to voluntarily have him sign an extension or file a warrant.
Mr. Pate, I don't know how you computed Mr. Stuber's DOC sentence. I trust you credited all good time credit and tried to present to the court the earliest possible release date.
That was primarily based on what Mr. Stuber had communicated to me. So I definitely wouldn't hold me to a specific date based on that. I'm gonna try to look him up here and see if I can provide any more information.
There's no official out date in Casper because I had already checked that before, but I'm trying to pull up the actual journal entry. I've got it.
Judge, the notes in his other case on 9/5 say his sentence was modified from 30 months to 22 months. And he was to get any jail time credit with 15% good time credit, 24 months post-release, but that's all it states.
So essentially, those are notes from a probation revocation proceeding, correct?
Correct. Yes, with Judge Crum.
That was done on 9/5.
So that would, if he got his good time, and since 9/5, I calculate that having him down to 15. So I suppose the next question is how much jail credit was awarded at sentencing.
And I'm pulling that up right now.
Golly, at this rate, when he gets done with his DOC time, he's not gonna have any probation time to serve on this case.
Your Honor, I think I'm gonna have to. This can't. I'm looking at the journal entry that's filed on September 11th of this year for the probation violation modification, and it's saying that he was only awarded no days of jail time credit, or one day or no days. So
The one I'm looking at shows 1 day jail credit and sentence to begin on 9/5 of 25.
So he was credited for none of the time that he's been serving recently?
that's at least what the journal entry indicates.
Well, that's
why I'm saying, Your Honor, it doesn't. I probably need a little bit more time to look into how that was calculated. And obviously, when you get multiple cases, it gets a little tricky as to where that gets awarded.
Well, it obviously wasn't credited there. At least the record in the case doesn't indicate that it was credited there. All right.
Your Honor.
Yes.
I believe the current incarceration, all that time went to this case up until that 9/5 date when he was ordered to DOC in the older case. So I gave him credit in this case for all the time up until September 5th.
All right. He was placed on a no bond hold in this case in August due to a failure to appear. And apparently was picked up a few days later and has been held in this case ever since. But I'm having difficulty reconciling the facts before the court with what that journal entry in the other case states. That they've only credited him with one total jail time credit day against that DOC sentence in the 24 CR 17 case. I don't see how that could be.
Your Honor, if I may, Joe Fabier said that I was credited 31 days altogether from the time that I turned, because I called and turned myself in and had the registration officers pick me up. And then I believe I didn't bring my paperwork, I'm sorry. And it said that it was credited 31 days.
Right. I don't know where that's documented, Mr. Stuber. I don't doubt what you say. I just don't know where it's documented. All right. But I understand your position, Mr. Pate. To some extent, anyway. At this time, the court will address Mr. Stuber personally, and I'll ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Stuber?
Your Honor, I thank all you guys for coming in today, and I know that what I've done, I'm owning it, just like I did on my first case. I finally came to the realization that I've tried to wiggle my way out of most things in my life, and I've never really owned my stuff. So I know what I've done. I've chose to put drugs and fast living in front of my daughter. She's the main one that I'm concerned about that's losing time for me. Since I've been in here, I've done a lot of thinking. It took me hitting the ground floor really hard to wake me up. I understand that, there is a possible sentencing of 8 to 22 months. Whatever the court deems correct, I think will be just. So I just put it in your hands and ask for mercy. Thank you, Your Honor.
Thank you, Mr. Stuber. I appreciate your statement. Court will proceed to sentencing in the Stuber case at this time. Court hereby establishes count 1 as the base sentence in the case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of E, thus placing him in grid box 5, drug E. The court hereby sentences the defendant to a term of 18 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered but declines to impose a fine in this particular case. The court does note that there is a special rule that the court will apply in this case. This crime was committed while this defendant was on probation, apparently in case number 2024 CR 17. The court will run the time in this case consecutively to the time imposed in 2024 CR 17 out of Butler County. Further, the special rule essentially would negate any presumption of probation in this case should the court elect to apply it, and the court will do that here. Mr. Stuber, the court would really like to see you out in the community over the next several months, facing a rehabilitative program and dealing with your drug issues. I've never seen a criminal history like yours. I share Mr. Sweeney's astonishment as to what the pre-sentence report revealed with all of the drug-related charges that you've had in the past. I've also noted that you've had some other criminal history as well, which was not drug-related. Because you're going to go off to DOC in 24 CR 17, you're not going to be in a position to be able to pursue any type of community-based drug treatment or rehabilitation program for what looks like at least a year, if not more. It does not appear that you're amenable to a probation in this case, and the court will simply apply the special rule and order a prison sentence in this case. This court has imposed the mitigated, in other words, the minimum sentence, if you will, Mr. Stuber, in this case. And I hope you earn every good time credit day that you possibly can to reduce that sentence. Furthermore, this court is against the concept of dead time, and I'm going to make sure that Mr. Stuber gets day-for-day jail time credit in one of these Butler County felony cases, and the court essentially will adopt Mr. Sweeney's computation of jail time credit. I don't think that there's necessarily anything patently erroneous about the officer's computation, but I think some time that he presumed would be credited elsewhere does not appear that it has been. And the court's going to grant the defendant 115 days jail time credit in this case.
Thank you.
There's no restitution order to be made in this case, unless there's a KBI lab fee that I need to consider. Mr. Sweeney, do I?
There is a KBI lab, Your Honor.
$400 KBI. Restitution is ordered. The defendant is ordered to pay a felony docket fee in this case. Any bids assessments are waived here due to the court's incarceration order. If these amounts are not paid in full within 30 days of today's date, the court will order that these would then become collectible by sending to a collection agency. And all amounts will become due, payable, and collectible after that 30-day period passes. Some point in the future, Mr. Stuber, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to seek expungement someday, you can address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have a right to appeal their conviction to an appellate court having jurisdiction. And if a defendant is unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, Mr. Stuber, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you, Mr. Stuber, that there are prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. I will remand Mr. Stuber's custody back to the sheriff of Butler County until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 18-month prison sentence, which the court has imposed here today. Mr. Sweeney, is there any other sentencing-related matter that the court needs to address or readdress?
No, Your Honor.
Mr. Pate, are you aware of any sentencing matters that the court still needs to address here?
Not at this time, Your Honor.
Mr. Stuber, I think you've come to a realization where your attitude has to change, and I think it has. If you can keep the mindset that you have today throughout your incarceration period, seek whatever rehabilitative help that you can within Department of Corrections, I think you actually got a chance to make it when you get out. And I hope you achieve that as soon as you can and that you are successful when that time comes.
Thank you, Your Honor. There's only one thing is I was told that to ask for the possibility of work release. I do have a daughter out there that I would like to help support or a PI job because the mother of my child is kind of struggling right now. So if there is anything that the court could help with that, just to make sure that I could get into one of those programs, I would appreciate that very much.
All right. Well, as far as jail is concerned, the court would have the power to order or authorize work release privileges, but you're now in DOC custody.
Okay.
I think that the rules will likely change for a DOC inmate who just happens to be still held in a Butler County jail facility. And I would expect, Mr. Stuber, that your transfer to the Department of Corrections will happen very soon after this. So I'm not adverse to that necessarily, but I just don't think that the sheriff's office is going to release a DOC inmate onto a work release program, even though you're incarcerated in the jail. So
yeah, no, I was talking about KDOC. It might have been just jail talk, but they were like, your judge has to approve you for KDOC work release or whatever, or have that as an option. So
I have no opposition to you being in any work release program that the Secretary of Corrections authorizes.
Okay, thank you, Your Honor.
No, I actually think you'd be a good candidate for that if such a thing exists.
Thank you, sir.
All right. If there's nothing further, then thank you all for your patience this morning in getting started. The Austin Van Stuber matter will currently be in recess, and this meeting may be ended.
His matter was a mess. I don't know how they're going to get that all sorted out. But the one day of jail credit, Judge Rickey was quite perplexed by that. All right, guys. 2.5 hours of joyous fun. And now it is time for me to take my medicine and go to bed. He's in community corrections. I have to let him out. You can just kind of see him right there. You see his face? His face is not lasting 2 hours. I'll be lucky if I stay awake long enough to change the video to monetized and clicked the buttons enough to save it. Believe me, I have had nights where I've fallen asleep just doing that process. It's not a very long process, but you get to a point where you're just running on fumes, and I'm there. Thank you for popping back in. I'm so happy to see you. Good night, Wire Mother, sweetie. Thank you, Manny. I really appreciate you reminding everybody. And I hope you guys all have an absolutely fantastic night. Thank you for coming and hanging out with me. Be safe, be well, sleep sweet, and much love. Did it not take? It didn't take. I did the things. I clicked the buttons. Try it again. Okay, I'm on it. Be safe, be well, sleep sweet, and much love.